Thank you so much for watching Law School Made Easy at Law School Made Easy 256. Today we want to go straight into Tort 2 and particularly want to discuss some of the cases in Tort 2. And one of the cases that we're going to discuss today is Caparo Industries PLC versus Dickman. This is the case we want to discuss. This case works on duty of care and in negligent misstatement. This case is locus classicus in negligent misstatement. But let us go now straight to the facts of Caparo versus Dickman. In this case, as we are going to see or appreciate, we had Caparo Industries that wanted to buy a company called Fidelity. Now, wanting to buy this company called Fidelity, they bought the company by doing a background check. When the Caparo Industries PLC did a background check on the Fidelity company, they found that this company was making a lot of profits, that the company was progressing, the company was making a lot of profits. So what Caparo Industries decided after the background check is to buy the company. But the accounts they relied on to buy the companies were made by Mr. Dickman. Now, Dickman had made these audit accounts to Fidelity, and he showed that this company was making a lot of money. Now, when the Caparos bought the company Fidelity, basing on the audit accounts which were done by Mr. Dickman, they later found out when they started to operate that Fidelity was actually making losses and they were not making losses. So now they were at crossroads. They did not know what to do because they could not sue themselves because now they had become part of the company. They couldn't sue the company because the company was now for the Caparo Industries PLC. So what they did, because they had relied on the audit report which was given by Mr. Dickman, they now decided to go and sue Dickman. Now, the issue before court was that whether Mr. Dickman owed a duty of care to the Caparos. So, court wanted to determine that whether Mr. Caparo owed a duty of care to the Caparos. And in court holding, what court held is that Dickman did not have any duty of care to the Caparos. Why did the court rule in favor of Dickman that there was no duty of care? Number one, court based on the fact that when Caparo was making the audit report, he did not know that it would be used by the when Dickman was making the audit report, he did not know whether it would be used by the Caparo Industries Limited. Now, because of that, he did not owe a duty of care. The assumption is that had he known that this report would be relied, maybe he would do a very good job. And therefore, in determining duty of care in the Caparo case, the three tests of the Caparo case came up. Number one, that the three tests of Caparo case is that one, there must be reasonable foresight of harm. Two, there must be sufficient proximity. Three, there must be fair and reasonable. Okay? What do we mean? That for you to allege that there is a duty of care that somebody's owned, you should have seen at the reasonable foresight. What do we mean of harm? That had Mr. Caparo known that his report would cause harm, reasonable foresight, then he would make a serious report. So as you determine a duty of care, the reasonable foresight of harm comes at the forefront. That is one of the elements which was brought out of the Caparo versus Dickman case. Then sufficient proximity. There must be sufficient proximity. That if you see with Caparo and Dickman and Fidelity Company, Caparo was very far from them. There was no relationship between Caparo Industries and Mr. Dickman. There was no any relationship. Why? Let us look at Donok briefly. In Donok, we based on a system of neighborhood, which Lord Atkins articulated. But now here we are saying there should be proximity, sufficient proximity, that relationship between the plaintiff and the defendant. That relationship must be clear. And then it must be reasonable, fair, for you to say that this person, you owe them a duty of care. So that is the holding. The three principles that arise out of the Caparo case is that there must be reasonable foresight of harm, there must be at all cost sufficient proximity, and then it must be fair and reasonable and just for you to be able to allege that there is duty of care. So we want to thank you so much for watching Law School Medicine at Law School Medicine 256. Thank you so much. Share, subscribe, like.